Hello, and welcome back to my ongoing coverage of the OceanGate Titan submersible tragedy, and the second part of the testimony of David Lochridge. In the first part of this testimony, we learnt about Mr. Lochridge's career pre-OceanGate, and then when he eventually joined the company, and the problems that he had. If you haven't watched that video yet, I highly encourage you to do so, as it is really eye-opening. In this video, we are moving on to Mr. Lochridge's termination from the company, and the subsequent legal battle he would eventually be involved in with OceanGate. We learn about various correspondence, including with the company that placed him under whistleblower protection. The amount of stress and pressure placed upon Mr. Lochridge and his wife was immense, and I have a lot of respect for the fight that they both had in them, despite the circumstances. The hearing leaves no stone unturned when covering the process, from the start of legal proceedings to eventual settlement. It really shows the wider effects created by this tragedy, just how many people were involved and affected by it. And once again, I'd like to commend the questioning by the US Coast Guard, which has enabled us to gather a clear and linear story throughout this hearing. So, thank you for clicking on this video, and I'll be back again at the end for a few final thoughts.
Prior to the break, you wanted to read a reference with regards to Coast Guard incident policies, procedures?
Yeah, this is to do with OceanGate's health and safety manual, which was in place prior to me starting the company, which I looked over. I just want to make reference to some of the comments. This is a statement made by Stockton Rush. OceanGate Incorporated, in fulfilling its legal obligation and its moral responsibility to provide a place of employment free from recognised hazards, has set forth this HSE policy statement, reinforcing its commitment to maintaining a safe and healthy work environment. This HSE policy statement is the cornerstone of the company's HSE management process. It is communicated openly and at every opportunity to employee, customers, vendors, and subcontractors, and has equal status with other primary business objectives. Violations of this policy should be immediately brought to the attention of management. The OGI HSE philosophy is that in the performance of our work, the health and welfare of the people involved and the protection of assets and the environment are the primary concern. No job is so important that we cannot take the time to do it safely. That wasn't the case. I just wanted to go on record to state that. This was a policy that was in place. Basically, on that, it showed open door policy. You get any issues. This was discussed with me at the start of my employment. That it is an safe environment to work in, and everybody is approachable if you have got any issues. It was so incorrect. It was untrue. The whole thing. Yeah, I just wanted to reiterate on that from their HSE manual. That was OceanGate.
And is that from your own experience for you not to be able to approach or bring up safety concerns, or was that from the experience of other operations, people that you managed?
So in terms of external to OceanGate, everywhere that I've worked, whether it's been from underwater inspection, when I was working as a construction diver, inspection diver, sub-pilot, there is always the ability to be able to actually sit down, whether it's during a job, after a job, pre-job, and discuss issues relevant to the safety and well-being of individuals, whether it be myself or somebody else that's going to be put in a position of imminent danger. This statement made it look as though it was open book policy. You have an issue, you could report it to senior management. I reported everything I possibly could to prevent senior management from going ahead and actually producing what they produced.
And so you haven't, the 25 years 25 to 30 years of subsea submersible operations experience. Throughout those 25 years, it was the industry standard to be able to come forward as a submersible pilot to express your concerns with regards to safety.
That is correct. And even if it was at the start of a new build for a new submersible, you can go to the designers, you can go to the project engineers, the project managers, the operations manager, whoever were running the project. You would sit down periodically and do tabletops on any form of component that was going onto the sub, what they think should be added, what should be taken off. It was, everybody would be involved in those discussions. You know, there was maybe just a handful of times with other organisations where you would come along, you would have a look, you had a finished product. As a submersible pilot, a diver, it is your right to demand to get information on something where you are putting yourself at risk. And it's to basically mitigate potential for disaster. So anyway, with regards to OceanGate, I approached them on everything, every little thing from boat operations. Anytime we had issues, I would formally put them down. If there was an incident, slips, trips, falls, any sort of incident, trapped fingers, everything was handed off to senior management. So there was a record in place. In terms of kickback, you know, on changing operations to the way that I would see fit with all my experience, eventually with some things they would buckle and they would basically allow me to do them my way, and it would show them that it's the safest method. When I went along to the company, you know, they were towing the dive platform out with a Bayliner sports boat, you know, until they went ahead and got the ex-Coast Guard vessel. The company, in my mind, even when I went across, was in its infancy. Even though it had been on the go since 2009, they had certain policies in place, and the reason I wanted to say this, to show they were highly inaccurate.
And so when you created the inspection report in 2017,
Yeah.
was your intention of delivering the report to Stockton Rush and Tony Nissen?
It was to highlight it to everybody. Everybody that's on that, they knew my displeasure in the components. They knew my dissatisfaction. They knew. I mean, as I said, I wasn't allowed into, like, I got told this, I'm not allowed to go into the board meetings because we know you will open your mouth. You know, it was things like that. I'm not shy when it comes to safety. If I don't agree with it, as I said, put it down in writing, submit it, and, you know, everywhere else I've worked, it would be addressed. It would be addressed at the highest level. I mean, on occasions, it wouldn't even reach that level where it has to go at the highest level. It's something that the ops team would deal with in-house, and corrective actions were put in place in operations manuals and standard procedures. Yeah, so I mean, in terms of reporting, I would report everything. My team, you know, as I said, it would get whittled down to next to nothing. We would report everything. Through me, I would submit that to senior management, and it was all held by them.
So what happened when you submitted this report to the senior management?
So when I submitted the report to senior management, I got a message to say that there was a meeting in the boardroom at Everett at the facility, and yeah, that meeting turned out to be a 2-hour, 10-minute discussion on my termination and how my disagreements with the organisation with regards to safety didn't matter.
And who was involved in this meeting?
So at the meeting, there was Scott Griffiths, who ended up being quality manager for Titan, the Stockton Rush CEO, Tony Nissen, Bonnie Carroll, and myself.
And throughout the meeting, did they ask you for why you had these concerns?
Most of the talking, I mean, as I said, I hope this entire recording becomes public knowledge and it's allowed to be played. It would be very beneficial in everybody hearing the disregard for safety and disregard for advice. But I mean, during this, they highlighted so many things. The viewport, as I said, you've all got copies of this and you've all heard it. Stockton, and I will quote, "I will tell you what the acrylic is according to Will. He says the acrylic won't work at all." Why did he say that? Because he wants to sell us another one. He had more acrylic and he said, why don't you buy one like this? Because that will make it to 4,000 metres.
Mr. Lochridge, I just want to make sure, what are you reading from?
That's basically, I've just done bullet points from my dismissal interview, which you've all heard.
Yeah, I don't, OceanGate, have you heard that recording or dismissal interview? We don't have it in the record. So can you just summarize your experience from that meeting, sir? Because we're not going to be able to enter that as an exhibit in the record.
Absolutely. No, I understand completely. Just for me, I mean, I've just taken bullet points from it. I mean, I think I know it's probably going to upset a few people. But I will quote, "It doesn't just implode, it screams like a mother before it implodes." Now, for the CEO to say that in front of other people, right, regarding that carbon fibre, I'm putting that on the record, and I know you've all heard it. It's disgusting, it's appalling, total disregard for safety, not even just for himself, but for everybody else. Didn't care. Engineering department, they didn't care. So during that meeting, myself and Bonnie, for the first time, we discovered, because I mean, I had been pushing for the PVHO paperwork and pressure test information for the viewport, and it was constantly refused, as you'll hear on this voice recording, which I hope OceanGate's attorneys do get a hold of as well, because it's certainly eye-opening. The viewport manufacturer states that the viewport is only good for about 1,000 metres. I'll take everything with a pinch of salt in terms of what the media are saying. There's been reports that he is now saying it was only good to 650 metres. I don't understand why it was ever produced. I mean, it's somebody that's going along the lines of PVHO, but I'm sure that'll all come out, the understanding behind that. With regards to the hull, the Tony and Stockton kept reiterating about the acoustic monitoring system, how that will basically give them the status of the hull. It will give them baselines on what is going on in the hull, which I completely disagreed with. All it's going to do is actually give you indication when you've got another strand breaking within the component itself. I voiced my displeasure during that meeting about the lack of NDT, the discussion about getting it classed. All that came up. And myself and Bonnie were completely dismissed, that way. With everything I'd raised in the report, they had an excuse, they had an answer, and not one of them gave me any confidence, not one of them. From cathodic protection to nothing. It was a disgrace.
Going into that meeting, were you confident that they would accept your concerns?
It'd have been naive of me not to think he was going to do something to me for doing this. I mean, I knew how Stockton would fly off the handle. I didn't do it out of badness. This report, I was asked to do it. Now, if it had been a case of the report, I hadn't been asked to do an inspection of it, I would have done one. I mean, that built Titan sub was weeks away from getting handed off to myself. And through that whole build process, seeing all those components, I was appalled. So either way, whether I did a report on the 18th of January or whether I did a report, say it was March, it was going to be ready, whatever, I would have, on paper, put down my concerns, because I was dismissed on every single occasion, from Chief Operating Officer, CEO, even the media and marketing manager, all of them, engineering director, a lot of them. The only other director that agreed with me on my concerns was Bonnie. That was it. And she's got limited experience, I mean, she had such good potential for being a pilot, a future pilot, and such good confidence and, dexterity and stuff like that. But Like, the thing is, even prior to my dismissal in this 2-hour, 10-minute termination interview, the contractors that were working for me, Tim Catterson and Chris Imes, voiced their concerns. You heard Tim yesterday state to you that he would never get in that sub. Chris told them he would never get in that sub. Now, Tim's probably got 30, 40 years of experience in subs. Chris Imes ran Delta submarines for 20 plus years. You know, at one point he'd probably done more dives than anybody else in the industry. They refused to dive the sub. They voiced their concerns. It wasn't just me. Other people did, and they were dismissed. They were dismissed by Tony. They were dismissed by the CEO. They were dismissed by the CEO, which make a mockery of this HSE statement that, you know, working in a safe environment where everything is reportable to senior management.
Did you make concerns to Mr. Rush about operating the submersible and moving forward in the upcoming testing?
Absolutely. So the main thing with the integrity of the hull, jumping on before we go on to the diving, the whole thing with it being classed, the submersible was meant to be classed. Part of that classification process is to do unmanned pressure testing of not only the viewport, which should be designed, you know, under the PVHO guidelines, but the hull itself, you know, taking it to 1 1/4 its max operating depth, pressurising that. There's cycles that you use in these pressure pots. And that's the thing, Stockton had been in communication with, I know this is the first hull, but he'd been in communication with the test facility. And then they decided that they were going to charge too much money, so that's why he decided not to do it at that time. All those concerns were highlighted by myself. Has to be done properly. I would never have gotten that thing. I will be complete hands up from the get-go. Tony Nissen, engineering director, gave me zero confidence in a product that I personally was supposed to be the chief pilot for or have under my care as a director of marine operations. Hands down, I would never go in that thing. And I wouldn't have. I really wouldn't have. And I wouldn't have encouraged anybody to go in it. And I think that's why I was quite vocal on the shop floor. Anytime any of my trainees were involved in anything, you know, whether they were asked to go and help the engineering team to go and help put a component on it, I would voice my concerns to every single one of them. And as I said, they all whittled out. Nobody wanted to do it. Nobody.
So with regards to the Deep Ocean Test Facility,
Yeah.
had they gone to would a test at the Deep Ocean Test Facility give the hull a little validity in your eyes?
Not validity, but there was so many imperfections in that first hull. As I said, and I'll reiterate and go back to seeing the external of the hull before they even, you know, before they applied this truck bed liner on the top. So many holes in it. That thing was not going to pass. If they'd have taken that over pressure, it would have failed. It would have, hands down, I could put money on it. It was a mess.
What did they say it was rated to?
4,000 metres.
And was that based upon a test or a previous test or a testing procedure?
That was based on Tony Nissen's calculations. Engineering Department, OceanGate.
Prior to your termination, were you consulted on the future test procedures and policies for the Titan?
So I gave them advisories. Stockton was insistent that he wanted to go in it for manned testing when they were taking the Titan to the Bahamas. I obviously voiced my displeasure. You'll have heard my comment in there saying, you know, about the accident investigation teams will get involved.
Can you summarize what you stated?
Yeah, basically, so the only way to get him to see any sense, I knew that hull would fail. As I said, it was an absolute mess. I suggested to them, look, why don't you, if you've decided that you're not going to go ahead and take it to the pressure chamber and get it overpressurized, put on a line, take it down, bring it back up again, but put your strain gauges on it. You know, all this acoustic monitoring that they were talking about. Put all that on the sub, take it down unmanned, keep doing multiple tests and bring it up. If I'd have said from the outset, I don't know, I mean, in hindsight, I knew he would have let me go. I knew he was going to let me go for the way I was being anti-project at that point. So whatever I suggested, it wasn't taken on board. None of it was taken on board.
Do you think the testing or the man testing of that submersible, how would that have affected the submersible industry?
If it had imploded with people in it,
Where you had made the recommendation to do unmanned testing over and over and over again.
yeah.
For him to go down in that solo
Yeah.
as a testing, how would that have affected, as you stated in your statement?
Nobody else does it. This is a one-off. This project's a one-off. Nobody else would allow that.
So man testing isn't a type of testing in the industry?
The hull would have to be pressure tested first to ensure the concept and the build of the submersible. Nobody's going to put anybody inside a submersible and take it down to depth without doing proper testing.
So just to confirm, for the first Titan hull, the
Yep.
testing plan was to do manned testing.
As was Stockton wanted. After he changed his mind about getting it classed, which would have provide oversight on the testing procedure itself, they came away from class, and doing that, the whole project just went in a completely different tangent. There was no safeguards put in place. There was none of them knew what was going to happen. You'll hear that in the voice recording as well. I state, you have no baseline for that vehicle. You don't know what's going on with it. And dismissed, as usual, dismissed constantly.
Did he understand the risks? Do you believe that he understood the risks for man test diving?
I think without actually saying anything, people know my opinion on Rush. His decisions, this was an ego boost for him. To go and do that manned and then follow it up with, and I know the individual's coming next week, Carol Stanley in it, who will describe that testing done in the Bahamas. I think hearing it from them firsthand, because I was away, the desire to do it manned, nobody's going to be affected. That's what he kept saying. Of course they're going to be affected. If you put somebody in an unpressure tested, uncertified vehicle and take it down and there's an incident, you know yourself, the accident investigation team would be down on everybody. And it would be harmful not only to the families of the individuals that go in the sub, which he ended up doing, but it just affect the rest of the industry itself. Fortunately, everybody else follows the guidelines classification. They'll listen to experience and they talk amongst themselves with all these task groups. PVHO get involved, ABS, Lloyds, GL, everything's done properly. Stockton went off on a tangent. The engineering department went off on a tangent. What for? To prove a point.
So after voicing your concerns over many months, and then through your report, your inspection report, and then following your 2-hour and 10-minute meeting,
That's correct.
what happened the next day?
So I was told that day that's us, we're finished, as you'll hear on the recording. So I was terminated. And then the chief operating officer, who I still don't understand why the individual running the organisation was not present in the meeting. He was actually in the building at the time. I don't understand why Neil wasn't there. To this day, I just don't understand. Was he told not to? I don't know. I'd love to know why. I was dismissed. I was emailed, no more correspondence, and I was emailed this letter saying that Stockton and I were at an impasse. So basically, we didn't agree on the way the organisation was going with how I think and know how it should have been done properly. I'm not saying I know everything about engineering. I'm not a degree qualified engineer. I've worked as an engineering technician. I've worked on mechanical systems, diving systems. I've been doing it a very long time. I was signed up to join the Navy in the late 80s. Even when I worked in the manufacturing industry, you develop, I would say, common sense. So you know what's right and you know what's wrong. And if you're questioning something before you put yourself at risk, go to others and get a second opinion. They didn't follow that path, which is unfortunate. So, yeah.
In your opinion, what do you believe was the impasse?
He had to dive it. I don't know whether it was a financial thing. He had to dive that year. I mean, that was the intention. There was clients lined up for 2018. They were booked. As far as I know, they were booked out for that summer. So how that's feasible, having a sub like that, a build quality like that, and then for these people that are running this organisation to think it's okay to put these people at risk.
And these were paying passengers?
All of them? Yeah, all of them. Yeah. Yeah.
And this was for Titanic Expedition 2018?
Correct.
So I just want to clarify, Mr. Lochridge, that when you say passengers for hire or mission specialists, that was the plan, but you never saw that occur for the prototype hull?
That is correct. Before that thing even saw rainwater falling on it, I was away. I had nothing to do with any of the operations manuals, anything. I had nothing to do with it at that point, which was alarming, which is why I followed the path I decided to do, so that to protect public safety, I went down the OSHA route.
For the record, so when you departed,
Yep.
when you were terminated in January of 2018,
Correct.
what was the condition of the first Titan?
It was, in terms of the build itself,
In terms of the build itself, was it
They-
operational? Was it ahead of it?
the only component that they were waiting on was a carbon fibre high pressure air cylinder, which was going to be mounted to the underside of the submersible. And I think they were waiting on the second Continue battery, which is the external battery to provide power for the submersible itself. From memory, that's all they were waiting on.
So once you were terminated, what did you do next?
Okay, so when I was fired, I'm obviously, well, not just concerned for myself and my family, you know, what are we going to do now? But I didn't want anybody going in that submersible. I mean, it was dangerous. You know, as I said, the build quality was atrocious. So I spoke to Labour and Industries, and that was within a week of my termination. I was terminated on the 19th of January. On the 6th of February, after dealing with Labour and Industries, I had a formal conversation with OSHA. Okay? That was the Occupational Safety and Health Administration. Okay? In the UK, we call it HSE. They are the governing bodies that deal with health and safety issues in the workplace. They also coordinate with the US Coast Guard with regards to seafarers. So I informed OSHA. I did a call and emails with Tobias Kramer, I think it is. He was the Assistant Regional Administrator for OSHA that were based in Seattle. He decided at that point my issues and my concerns about public safety, about the public going in the submersible, were serious enough that he wanted me, he said it to me, I knew nothing about this, to be put and placed under the whistleblower protection scheme. I spoke to one of the individuals that dealt with the whistleblower protection scheme, and I did a formal interview process to be enrolled into that scheme on February the 8th, 2018. I did an intake interview. We did many calls with each other, emails, obviously see when we got. Obviously being a seafarer and working for an organisation that's got marine assets, between myself and OSHA determined that I am a seafarer to allow the Coast Guard to get involved. That was on February 23rd, 2018. February the 28th, Bonnie Carroll, who you spoke to yesterday, she quits her job, citing my safety concerns in a resignation letter.
Her job at OceanGate?
Yeah, correct. Yeah. So, because OSHA had decided that my concerns were serious enough for public safety and for the employees of OceanGate, you know, I mean, no matter what, as much as I didn't get on with Stockton, I wouldn't want to see anybody dying for the sake of going in a sub. It's a magical place. I love it. I'm very passionate about what I do. If there's risk like that, don't do it. You know, everybody wants to go home with their families. So at that point, OceanGate sends a letter to OceanGate and they formally inform the Coast Guard about my complaint, about my concerns. I do have all my documentation and my correspondence with OSHA on that, but one thing I would like to go on the record and provide to yourself, which is available just now on the OSHA website. I just want to put it into perspective as a seafarer, how OSHA determined under the Whistleblower Protection Scheme I was protected under the Seafarers Protection Act. The Seamen's Protection Act, SPA, prohibits persons from retaliating against seamen for engaging in certain protected activities pertaining to compliance with maritime safety laws and regulations. Protected activity. A person may not discharge or in any other manner retaliate against a seaman because the seaman, and I've got these highlighted for yourself so it's on the record, refused to perform duties because of a reasonable apprehension of serious injury to the seaman, other seamen, or the public, if the seaman has first requested that their employer correct the dangerous condition. So going by OSHA's guidelines, and they confirmed, obviously, all my experience and documentation, which I gave to OSHA, they confirmed, and that's why they took me seriously. At that point, they put me under the Whistleblower Protection Scheme. I can't remember offhand, there's like 40 different levels from different industries. Jumping on to the same component, which is all relative to the lawsuit that OceanGate took out against me. So, unfavourable employment actions. A person may be found to have violated SPA, Seamen's Protection Act, if the seaman's protected activity was a contributing factor in the person's decision to take an unfavourable employment action against the seaman. An unfavourable employment action, and I'll give the examples, firing or laying off, which happened. During the lawsuit, which OSHA were totally up to date on, intimidation or harassment, which was very public, which I know everybody's seen the lawsuit, it's available online. Making threats, which they did to me and my family. Blacklisting, intentionally interfering with an employee's ability to obtain future employment. And last but not least, which is controversial, reporting the employee to the police or the immigration authorities. I had a good reason for being under the Seamen's Protection Act with OSHA. They deemed and approved it. That's why they passed everything to the Coast Guard. I've obviously got all my correspondence with OSHA here, which coincides with my timeline of everything which I'd already submitted to you. Would you like me to go into more detail on everything that we communicated with OSHA and how OSHA communicated with myself?
Yes.
Okay. I was under the Whistleblower Protection Scheme for 10 months trying to stop OceanGate from doing what they did. And I'm just going to read through everything in terms of notes and communications with OSHA. Okay, so and I can give you a copy of this. This is OSHA paperwork that was sent to myself and to OceanGate's attorneys. It's basically the case activity worksheet. This is just to let OceanGate know that the OSHA were putting me under the Whistleblower Protection Scheme because of the Seamen's Protection Act. So on the allegation summary, which came from OSHA, and that was issued by Paul McDevitt, on or about January 23rd, 2018, Mr. Lochridge was discharged in retaliation for raising safety concerns about the development and testing of a submersible marine vessel. So that's just to put on record, I was under their care at that point. This is after I'd done my intake interview for the Whistleblower Protection Scheme. Jumping on, I do the intake interview. I give them everything. I gave them the safety report. I gave them photos. I gave them as much information as I possibly could. The next instance after the Coast Guard are informed of my complaint, because OSHA took it seriously, that was on February 23rd, and I've got the correspondence for that. The next thing is Bonnie. Bonnie quits, citing my safety concerns and hers, and I informed OSHA of that. Just to let, for the record, and this is all on email, and this is me emailing OSHA. Just an update to let you know that OceanGate Director of HR and Finance, Bonnie Carroll, has left her position due to the same safety concerns as issued in my report, and also the unlawful termination of myself. Bonnie has said she would be more than happy discussing with you or your team all her concerns for health and safety to support my case. I also have the support of 3 very high-profile industry experts who, albeit have not seen my report, but they would be more than willing to discuss their concerns for the safety of crew and passengers, and how what is going on at OceanGate will infect the entire industry. So that was dated February the 28th. Email from Paul McDevitt, my, call him caseworker at OSHA. We sent a letter, this is March the 7th, 2018. We sent a letter to you in OceanGate notifying you that OSHA will be investigating your complaint of retaliation. The US Coast Guard has also been notified of your complaint. So that was the official correspondence that the Coast Guard were notified of what happened. I also reiterate on March the 7th. Thank you so much, Paul. I really appreciate all your assistance with this matter. As mentioned previously, Bonnie Carroll will also verify all my concerns if you require her to do so. They never did. They never got in touch with Bonnie. I gave her email, phone number, not once.
OSHA stated that the Coast Guard was notified of your Seamen's Protection Act status, correct? And was there any discussion with OSHA on what the expectation was of the Coast Guard, or what you could expect the Coast Guard to do?
No, they just, what they said was they wanted to get the Coast Guard involved because of the circumstances with regards to the marine vessel that was being manufactured and it being a passenger carrying vehicle. Throughout the 10-month period, I will state I had no interaction with the Coast Guard, and all correspondence, anytime I would speak to Paul on the phone or Tobias, I was told it's in hand and we deal directly with the Coast Guard on your behalf. So I had no interaction with the Coast Guard.
Did you ever personally reach out to the Coast Guard?
No, I did not.
Okay.
No. I thought, in hindsight, I was in good hands with the people that administer health and safety within the US. So that was March the 7th. OSHA sent a letter to OceanGate and informed the Coast Guard of my complaint. The next event is my wife and I were served a settlement and release from OceanGate's attorneys, basically threatening us.
What was that date?
March the 16th.
And what was that for?
So OceanGate wanted me and my wife to sign this settlement and release. They were basically demanding that I pay them money to settle with them because they'd had to hire an attorney to represent them in the matter dealing with OSHA. On the thing, it basically comes up non-disclosures. They state that if I don't, they will contact previous employers, ex-spouses. OceanGate will contact US immigration, fraud, theft. Everything's in this.
And what is that?
That is a settlement and release agreement that OceanGate's attorneys served to my wife and I in March 2018 to get me to back off. So we declined. I spoke to OSHA about it. I sent everything to OSHA. It was important that they had all correspondence of the documents. And OSHA's response to this on March the 16th from my caseworker, Paul McDevitt. Mr. Lochridge, this happened in another one of my cases. This is called a SLAP lawsuit. Read more about it here by clicking this link. The state of Washington has an anti-SLAP suit law, but in 2015 it was ruled unconstitutional by the Washington State Supreme Court. You might want to consult an attorney. I will ask our lawyers about this as well. I think OceanGate may be using this to pressure you into settling your OSHA complaint. The lawyer representing OceanGate specifically asked me if you were interested in alternate dispute resolution. I know this must be distressing, especially as you're going through the pain of losing your father. Try not to think about this until you get back to the US. I will let you know if I hear any more from OceanGate's attorney or OSHA's lawyers. Never once got any correspondence from OSHA's lawyers. At that point, I spoke to Paul on the phone and I said, absolutely no way I want to proceed with this OSHA claim. It's public safety.
I'd like to understand the basis for OceanGate's
countersuit against you. What was the allegation that you had done?
So the lawsuit was further down the line. They wanted me, it was basically a settlement agreement. They wanted me to walk away by issuing all these threats against me. It wasn't, at that point, it wasn't a lawsuit. They threatened in this that they would proceed with legal, that they would basically sue my wife and I if I didn't pay this. So I refused.
Understand, sir. Thank you for that clarification. But
Yes.
what was their basis what was the allegation that you had violated?
So they stated that my whistleblower claim under the Seamen's Protection Act was not valid.
Because you had released proprietary information? Was that the allegation?
Potentially. I don't know. From a legal point of view, I'm not an attorney, but there's no way I was walking away from this. The OSHA had already done my intake interview for Whistleblower Protection Scheme. Whistleblower Protection Scheme protects people that are in employment and have been laid off because of safety issues. I was under their protection at this point.
Did you ever release any information to any other agencies or any other media beyond OSHA?
Media, no. And other agencies, no.
So the only entity you had released any records to
Yep.
was OSHA?
Correct.
Thank you. Please proceed, sir.
No problem. So I refused to pay this. I spoke to my caseworker when we got back, and then I received the email correspondence on March the 19th from my caseworker, Mr. Lochridge. I would like to discuss the possibility of amending your complaint after you return to the US. There is no rush to amend it, and I don't want to make matters worse for you. Give me a call later in the week and we can discuss. I did call him later in the week. I didn't understand why OSHA are asking me to change my complaint. I'd already submitted the complaint. They were happy with the complaint. They took all my points about the potential risk of the submersible actually coming into action. They took me seriously, as did Labour and Industries when I was first terminated from my project. So that didn't make sense to me. I reply on April 22nd as well, an email confirmation. Afternoon, Paul. As you can imagine, it's been a very stressful time for my wife and I over the last 5 weeks since receiving the threatening 41-page letter from OceanGate's attorneys. And I say, it's a big long email, I'm truly at a loss and wondered if OSHA had any guidance that they could give and what sort of support is available. Basically, I was looking for advice. I was wrongfully under the assumption that I was going to be protected, which had been told to me initially when I spoke to them, by disclosing all this information so that they could actively investigate OceanGate, and to be threatened with the immigration, the fraud, all that sort of stuff. It just didn't make sense to me at the time. As I say, I'm no attorney, but 23rd of April, Mr. Lochridge, I can well imagine the stress you've been under. I'm glad you've retained an attorney. I had to get an attorney because OSHA weren't helping me. This was another one which was totally out of the blue, and my caseworker knew that I wasn't walking away from this. Okay, this is the OSHA caseworker. Please let me know if you want to take advantage of OSHA's alternative dispute resolution. It's an ADR process. I would think this would be the quickest way to resolve this dispute with OceanGate. Now that you are represented by an attorney, you are on an equal footing with OceanGate. Talk to your attorney, and if he is in agreement, please send in the ADR form and I will contact OceanGate's attorney to get the process going. What do I say to that? I don't want to do an ADR. I made it clear I was no interest in doing an ADR, no interest in agreeing to this settlement and release contract that they sent through. I wanted to stop this.
In the last email, you had mentioned revising your complaint.
Yeah.
Did that come up again?
No, it didn't make sense. I told them no. That's the thing. When I spoke to Paul, and I said, absolutely no way, we need to go ahead with this. Okay. Even at that point, I felt like there was no urgency on their behalf in getting this stopped. And at this point, the sub was already down at the harbour and going through trials in international waters with a vehicle that's not classed.
And where were those tests occurring?
Everett. in Everett, in Seattle, Washington.
And when you say international waters, do you mean offshore?
No, sorry, they were done in US territorial waters. Correction. I do apologise for that.
Okay, yes, sir.
Yeah. So the alternate dispute resolution, this is from the US Department of Labour, just to explain to people what it is. The term alternate dispute resolution, ADR, means any procedure agreed to by the parties of a dispute in which they use the services of a neutral party to assist them in reaching agreement and avoiding litigation. Types of ADR include arbitration, mediation, negotiated rulemaking, neutral fact-finding, and mini-trials. With the exception of binding arbitration, the goal of ADR is to provide a forum for the parties to work toward a voluntary, consensual agreement as opposed to having a judge or other authority decide the case. I wanted OSHA. OSHA were taking me seriously. I was under their protection. If I'd went down the route of anything else, I don't know what would have happened legally to myself and my family.
Sir, were you having conversations with your OSHA caseworker? Or
Yes,
was it all by
I was
email?
talking to him on the phone. Yes.
Were they encouraging you to go the ADR route?
Yes.
And you said that you
No.
would proceed on without that?
Absolutely. I had no interest in doing an ADR.
Was your attorney involved in those conversations?
So at the time, I've had 3 sets of attorneys dealing with the OceanGate lawsuits. So all in, the first one, the first attorney, he decided to pass this on to somebody else because it was getting so serious. But even then, he said to me, we've got a good case here. And he agreed with me, that initial attorney, we need to stop this. I mean, I don't think I could have been any more vocal in stating my displeasure at this vehicle, potentially, a matter of weeks down the line from my dismissal, paying passengers to the Titanic. That's what they wanted to do. And as you've seen, as you've already heard, they were very push, trying to get this out the door as quickly as possible so they could start making profit.
Okay, sir, please proceed.
Yeah. Okay, July the 9th. And I have had several conversations with my caseworker in between this. It was a day my wife and I were going home for my father-in-law's funeral. I answered the door and I was served papers from OceanGate's attorneys. A lawsuit had been served against myself and my wife. So straight on to OSHA. Good afternoon, Paul. I've attached scans of the court summons OceanGate have had served on me and my wife, Carol. My attorney feels it would be prudent to send you a copy. OceanGate's further retaliation after raising concerns about health and safety issues leading to my unlawful dismissal have reached a head. And no matter what suggestions my attorney made to settle the matter early, he has been met with resistance and further demands. Their accusations are unjust, untrue, and once again, their threatening behaviour is upsetting to my family, especially, I stated, we both lost our dads in a matter of months. So yeah, he was aware of this. His reply, July the 10th, and this just shows you how slow things were moving. And as I said, I was under whistleblower protection, start of February. This is July the 10th. My condolences to you and your wife. I will investigate your complaint as quickly as I can. Please note that at this time, I have 11 cases that are older than yours. I will be in contact with you as needed. Thank you for your patience. So at this point, I'm paying for attorneys. I've got OceanGate suing me, and I've got OSHA. I've got 11 cases ahead of them. I spoke to Paul on the phone, and obviously my displeasure at where we were at. We discussed the whole whistleblower protection scheme, how I'm meant to be protected. I asked about OSHA's lawyers again and again. What can you do for me? I was told initially that they would provide legal representation in the event of any form of retaliation, which it also states under the SPA, Seamen's Protection Act. It never happened. So it was all on me. So went on and on. I'm being sued at this point. And we decided to change attorneys. We had to go with a bigger firm. And that was in July 25th, after OSHA stated that they've got 11 cases ahead of us. And then at that point, with our new attorney, we decided the right thing to do. Since OSHA were dragging their heels and doing nothing, we decided to countersue OceanGate. But rather than what OceanGate did is they decided to sue us in civil court which remains behind closed doors. And we decided to do it in federal court so that it would become public knowledge and the public have complete information from the get-go of that case. So we countersued them on August 15th, 2018. OSHA throughout were notified of everything. I constantly updated them on everything that was happening legally with OceanGate, their behaviour towards us, threatening.
Mr. Lochridge, when
Yes.
you talked to OSHA,
Yeah.
were you talking to their legal before you did that
No,
action?
they
or your
never once did I speak to OSHA legal. I had a caseworker that I had to go through. On some of the emails, you see that it also was passed on to this Paul McDevitt, my caseworker, he had a supervisor. Even when I spoke to him on the phone, he said, I'll resort to my supervisor. And then there was the other individual was Tobias Kramer. I think he was the assistant regional something for OSHA. So they all knew what was happening.
You never had email contact with an attorney either?
With
OSHA?
OSHA's attorneys, no.
Okay,
No.
thank you.
No. August 29th. Good morning, Paul. Just a quick mail to see what, if any, progress has been made in my claim. You mentioned several months ago about sending a second letter to OceanGate highlighting a second act of retaliation by them against me. I understand the manufacturer of the insufficient viewport that is installed in the submersible Titan is extremely concerned. As previously mentioned, the viewport was designed in-house at OceanGate and the manufacturer would only build and certify their design to 1,000 metres. OceanGate plan on taking the submersible to 4,000 metres with passengers who are unaware of this. The viewport manufacturer expressed his concerns and said he could design and build a viewport to the desired depth of 4,000 metres, but OceanGate refused. Over and above this issue, which was highlighted at my unlawful termination, there is still the issue of all the other safety points that are critical to paying public and OceanGate's crew safety. So even 8 months after, I'm still reiterating to OSHA, and have it in email, that this is serious. His reply on August 29th. David, I have not started actively investigating your complaint. I still have several other older complaints that I'm trying to finish up. I will get started on yours in the near future. When I do, I will be in touch. Now, I don't need to spell it out how upsetting that was for myself, my family. I'm being sued. The one organisation that can actually step up and do something to stop this, to actively carry out an investigation that could go down to the facility, which I suggested several times to them. OSHA that I was dealing with were based in Seattle. OceanGate were based in Seattle. They were just up the road. Not once during all of this did they actually go down, pay a visit, talk to them, nothing. And the fact that I was told that a second act of retaliation against myself would be OSHA would step up and basically raise these concerns with OceanGate, and it wouldn't be good for OceanGate. Never happened. Never happened.
Mr. Lochridge?
Yes, sir.
During that back and forth, or the several months, did you ever get an update on the Coast Guard?
No, not at all. The only thing that any time I mentioned the Coast Guard, because they'd made that initial correspondence, my caseworker said to me that we will deal with that on your behalf. They will pass all the information on to the Coast Guard. Now, I don't know how it works in terms of that understanding between the two agencies. I don't know. I don't know whether they submitted all the documents to the Coast Guard initially when it was approved that I was under the whistleblower protection scheme. I truly don't know. Or whether it was just a quick email to say we are currently investigating something that relates to a seaman. I don't know. I don't know.
As your frustration built during this process,
Yes.
was there a reason that you didn't reach out to the Coast Guard directly or another agency, or was it because of the lawsuits?
Yeah, so I mean, jumping back onto one of the emails, and I correspond with OSHA Sunday, April 22nd. So this is, this was the one where I said it was a stressful time for my wife and I over the last 5 weeks since receiving the threatening 41-page letter from OceanGate's attorneys because of the immigration implications. As I said, I'm an immigrant in America. I'm not a citizen. I'm a permanent resident. This is in my email to OSHA. After looking online at the Justice Department to see if they could intervene, I found the following paragraphs. I wondered if you could speak to your OSHA attorneys to see what their thoughts are on me involving them at this stage and if it would be beneficial at all. The reply was on April 23rd. I just hadn't highlighted it. OSHA and the US Department of Labour do not enforce the Immigration and Nationality Act, and we cannot provide you legal advice. I would talk to your attorney to see what he thinks is the best strategy moving forward.
Understand. And sir, I'd like to just touch on if you had a relationship with the local Coast Guard at all ahead of all these events in Seattle.
The only, as I said, the only interaction was, it was to do with, anytime we were doing operations in Puget Sound, not necessarily, Everett Marina doing the dunks, the test dunks, but anytime we were going out, and it was just to give them the heads up that we were heading out. That was basically it. I know, and remembering back to it now, Stockton's disapproval at me doing that, but it's important you let the authorities know that you're about to actually do a dive, and the port authorities for incoming shipping. So,
thank you, sir.
No
Please
problem.
proceed.
Okay, between August and November 2018, obviously this is information between my old attorney, we do not employ them anymore, and OceanGate's previous attorney. We were served discovery, they were served discovery. There was a lot of documentation going backwards and forwards. That's all in legal. I have none of that here, but I can provide it if you need it. So lots of phone calls, seeing where they were at. They didn't do anything to help us. My confidence was gone in, can I loosely say, the authorities, because OSHA are the ones that are meant to, OSHA were dealing with this. They were my point of contact and did nothing. Okay, so jumping on November to November now, just shows you how long this went on. And as you can imagine, a lawsuit is no easy thing, especially when you're being threatened with theft, fraud. My attorney and their attorney, they agreed. My wife and I had decided, this is, I'm not going to say pointless, but it was going nowhere, and it was causing more hurt for us, and obviously financially. And it's difficult. So Carol and I decided to walk away from it all. And so we decided to walk away from the lawsuits and informed OSHA of this, as they hadn't started working on my case. And genuinely, it was too much for us as a family. It really was. So November 24th, OSHA sent a settlement and release agreement between myself and OceanGate, and it literally was a walk away, which I've got here. It was a walk away. There was no financials. I never paid a penny to OceanGate. I would state that clearly. I gave them nothing. They gave me nothing. I stated that I'm dropping the OSHA case. OSHA weren't doing anything. I decided I wasn't going to put myself or my family through any more of this. So we decided to walk away. OceanGate were happy with that. So at that point in November, we signed a declaration with OceanGate and settlement and release with OceanGate and with OSHA. OSHA get a signed addendum back from OceanGate. So we Carol and I signed this in November 28th, 2018. OSHA get OSHA had to chase up OceanGate's attorney to get the signed copy from Stockton to say that he was happy with it all. And they received that on December the 12th. On December the 13th, 10 months and a week after I was placed under the whistleblower protection scheme, OSHA confirmed the case is now closed, and on the documents which you've got a copy of, the US Coast Guard is informed of such. So correspondence from OSHA. I hope you have no objections to me reading this out. You do have a copy of it. December the 13th, this is addressed to OceanGate Incorporated and myself from OSHA, US Department of Labour, and this is from Tobias Kramer, who is their Assistant Regional Administrator. The people that are CC'd on this are OceanGate's attorney at the time and the United States Coast Guard. December 13th. Dear Mr. Lochridge, this is to advise you that pursuant to a settlement agreement reached between the parties, our agency is closing the investigation of the above-referenced whistleblower complaint. OSHA's authority over this agreement is limited to the statutes it enforces. Therefore, OSHA approves only the terms of this agreement pertaining to the Seamen's Protection Act. Having reviewed the settlement agreement, I find it to be fair, adequate and reasonable. The settlement agreement satisfies the core elements in accordance with OSHA's policy, and it is reasonable in light of the merits of the case. OSHA considers the matter closed and will take no further action. The settlement agreement constitutes findings in a preliminary order under SPA, Seamen's Protection Act, and complainants' and respondents' approvals of the agreement constitute failures to object to the findings and the preliminary order under the Act. Therefore, the settlement is an order enforceable in an appropriate United States District Court under the Seamen's Protection Act. Please note that if OSHA's practice to not disclose the terms of the settlement except pursuant to FOIA process, I'm not sure what that is. And then
For the record, that's the U.S. Freedom of Information Act requirements.
Thank you, which hopefully everybody has now. So yeah, so that was my final correspondence with OSHA, and that was December the 13th.
Just to clarify, did you use the ADR process to come to that settlement, or was it outside that?
No, it was outside that.
Were you given any instructions about limitations on what you could do after that settlement?
Absolutely. Okay, I had to sign a declaration, basically talking about the quality inspection report. I'll go on to the settlement and release, mutual waiver and release of liability, retraction of OSHA claim, and claims arising from non-compete agreement. In exchange for the promises and commitments set forth in this agreement, Lochridge, OceanGate and OceanGate's owners, investors, attorneys, agents, employees, affiliates and subsidiaries hereby forever waive and release all claims they have or may have against one another, whether known or unknown, asserted or unasserted, except those obligations arising out of this agreement. Lochridge specifically agrees to withdraw the OSHA claim and not support it in any further hearing or proceeding, and will not voluntarily testify in support of his OSHA claim or any other or future OSHA claim against OceanGate. OceanGate hereby releases Lochridge from the non-compete agreement appearing in David Lochridge's employee intellectual property agreement, and all claims arising from said non-compete agreement or breaches of the same and are hereby released. The rest and remainder of David Lochridge's employee intellectual property agreement shall remain in full force and effect following the execution of this agreement, subject to all time limitations set forth in the intellectual property agreement, e.g. the non-raiding agreement, by its terms as binding on Lochridge for 12 months following the end of his employment. OceanGate covets and agrees it has not contacted Vulcan Maritime or any representative thereof or any representative of MY Octopus or any of Paul Allen Company regarding any non-disclosure agreements between David Lochridge and Vulcan. OceanGate covets and agrees that it will not in the future contact Vulcan Maritime or any representative thereof and or any representative of MY Octopus or any of Paul Allen Company regarding any non-disclosure agreements between David Lochridge and Vulcan. OceanGate covets and agrees that it has not contacted nor will contact US immigration authorities with any information related to Lochridge visa applications. Nor will OceanGate contact any potential creditors of Lochridge, including ex-spouses or previous employers, with information on his current and past earnings and financial status. OceanGate specifically agrees that it will not make any statements or take any other actions accusing David Lochridge of theft of OceanGate property. Each party agrees and covets to the other that he or it will not make any statements or take any other actions to disparage, defame, or compromise the reputation of the other party in any forum. Lochridge covenant and agree that neither has disclosed and will not in the future disclose, nor will they permit their attorney to disclose, any information about OceanGate, whether or not such information is confidential in nature or a trade secret, to any third party unless legally required to do so, e.g., pursuant to a lawful subpoena. Save only that Lochridge may disclose the dates of employment and his position at OceanGate to potential employers only. Lochridge represent, warrant and covenant that neither of them has any copies, whether in paper, electronic or other form, of any confidential information of OceanGate, including without limitation any copies of David Lochridge's Cyclops 2 Quality Inspection Report, dated January 18, 2018, or any drafts thereof, save only the redacted copy provided by OceanGate to OSHA in its responsive letter dated March 15, 2018, and the documentary information disclosed by OceanGate in the litigation pursuant to the laydown rules of the Rules of Civil Procedure, documentary laydown. Lochridge covenant that within 3 days of dismissal of this litigation, they will destroy and instruct their counsel to destroy all copies of the documentary laydown by OceanGate. David Lochridge covenants that the declaration attached hereto and dated November 9th, 2018, constitutes, to the best of his memory, the entirety of his communications from and after January 1st, 2017, with persons relating to the safety issues concerning Cyclops 2, Titan, and the technology upon which it's based, accepting only communications with officers and employees of OceanGate and privileged communications with attorneys for the purpose of resolving this matter. David Lochridge specifically covenants that other than the communications listed in the attached declaration, he never instigated or had any involvement with the communications questioning OceanGate's testing policies and procedures for Cyclops 2 Titan, or the business plans of OceanGate. The parties agree that damages in the event of a breach of this obligation or representation in paragraph 3 and 4 of this agreement are difficult to estimate and would be difficult to prove. As liquidated damages and not as a penalty, therefore, the parties agree that any violation of paragraphs 3 or 4 hereof shall result in an award of liquidated damages in the amount of $10,000 per occurrence.
After signing that,
Yeah.
was it your understanding that you could not approach the Coast Guard or another agency with safety concerns about the Cyclops 2 or Titan?
Yeah, pretty much.
Unless you were subpoenaed to provide information?
Yeah, that's why gladly people want to know anything, subpoena me.
There were several companies mentioned. I think I heard Vulcan.
Yeah.
What were the basis of the other companies? Are they relevant?
They were other submersible companies that I'd worked for. Yeah, it was.
Thank you.
They were just intimidating.
Can you talk about any involvement you had monitoring or with OceanGate after that?
There was nothing. There was no correspondence with OceanGate whatsoever. Is that what you mean, sir?
Did you ever have any communications with employees of OceanGate after that?
Yes, I did. The contractors, Tim Carterson and Chris Imes, both subcontractors for the company OceanGate, no staff employees. I never spoke to any staff employees at all.
How long did you stay in communication with the contractors?
I'm still in communication with Chris Imes and Tim Carterson, who I've known for years. We did, even within the last few years. We never went into depth. Tim, because of the threat of the $10,000 per occurrence, very reluctant to speak about it. And I know Tim was still working with the organisation, so he knew there was a safety report. And I truly believe what Tim said yesterday, he's probably never seen it. And I hope, seeing what he saw up today, he will understand why I followed the path that I did. But in terms of communication, yes, the two contractors, nobody else.
Were you in contact with those contractors during the Titan operations during the summers of 21, 22, and 2023?
So I met with Tim's sister, lived close to us. We met, we never even discussed we basically never discussed OceanGate. So we do have a lot of mutual acquaintances it's a very small industry. So I'm sure Tim will come up, take the stand on that as well. But no, we didn't. He knew I was displeased and something happened, but yeah.
Were you aware of the second hull doing operations off of Canada? I mean, for all three of those sessions or years, from 21, 22, and 23?
Oh, absolutely. I mean, OceanGate were, as everybody knows, they like to promote themselves on social media, so we could see it. And I'm not going to lie, myself and my family, every year that they would go out, it was like, is something going to happen this year? Like, I mean, the way the company were going with this project and bypassing all the standardized rules and regulations that are set in place by people with experience, years and years of experience, from the US military to the Coast Guard, the classification agencies, even manufacturers of some of the equipment, they bypassed it all. It was inevitable something was going to happen, and it was just when.
So that concludes the second part of David Lochridge's testimony, and I'll be back in the next couple of days with the third and final part. I covered the OceanGate HSE statement in my recent video when I looked through some of the documentation submitted for the hearing. As Mr. Lochridge reads from the document, he emphasises the claims made in that document regarding health and safety, and how OceanGate would go above and beyond for safety, with no job too small or unimportant. Mr. Lochridge states that this was not the case at all. It really would be something if the public got to hear the audio recording that Mr. Lochridge speaks of, from the 2-hour meeting that led to his termination. In that meeting, he states that various safety issues were discussed, such as the viewport, though nothing he said was taken aboard, as he was considered to be anti-project at that time. He elaborates on some of those problems, such as unmanned testing being abandoned due to it costing too much, for example. He then confirms that, despite lack of testing, OceanGate claimed Titan was rated to a depth of 4,000 metres, a claim based solely on Tony Nissen's calculations. When speaking about testing, Mr. Lochridge explains that Stockton Rush was adamant about performing manned testing of the vessel despite his concerns. Mr. Lochridge describes it as an ego boost for Mr. Rush, who would go on and perform manned testing. He explains how, after there would be no classification of Titan, Stockton Rush and the engineering department went off on a tangent, and that, rather than consult outside opinion, did the work in-house to, as he states, prove a point. After his termination from the company, we learn how Mr. Lochridge was placed under Whistleblower Safety Act by the company OSHA, which promised to defend him and act upon any intimidation or action against him by OceanGate. This must have been an incredibly stressful time, considering OceanGate then began to threaten action against Mr. Lochridge and his wife, with claims that they will contact ex-employers, immigration and ex-spouses, as well as citing fraud and theft. This, of course, all boiled over and led to a court case, in which Mr. Lochridge and his wife countersued OceanGate, all off their own backs may I add, as OSHA were failing in providing the support that they promised. I have to commend both Mr. Lochridge and his wife, considering it took almost a year from his dismissal to the point where a settlement was reached. And what is also frustrating is that while OSHA were dragging their heels, OceanGate were moving full steam ahead with the Titan sub. I can only imagine what it was like, stuck in the middle and unable to get any of the support promised. So we've now heard about Mr. Lochridge's career, both before and during his time at OceanGate, and now also about the legal battle that followed, and I have to say, it has been highly enlightening. I'm looking forward to getting the third and final part uploaded, so we can bring a close to this testimony and learn all that we can learn from it. As ever, thank you very much for watching, and if you haven't already, please subscribe for future uploads. Bye for now.